Democracy Watch, I think, on Zoom.
Thank you, Madam Commissioner. My name is Duff Conacher. I am the co-founder of Democracy Watch. Thank you for this.
Okay, you're in front of me now. Okay, sorry, you weren't at the back.
No worries. My name is Duff Conacher, and I am co-founder of Democracy Watch. Thank you, Madam Commissioner, for this opportunity to make this closing statement to the inquiry. Although Democracy Watch hopes that it will hear over the next month or so from those involved in drafting the final report, given it has submitted 6 detailed policy papers to the inquiry. As the policy papers detail, there are significant loopholes and flaws in several Canadian laws that make it effectively legal to secretly and unethically interfere in Canadian politics, especially given that enforcement of many of the laws is ineffective. The loopholes are in the elections, political finance, lobbying, and ethics laws, including loopholes that allow for anonymous secret online disinformation and misinformation campaigns. Unfortunately, through its hearings since last January, the inquiry has not heard any testimony about the following loopholes that make secret, unethical, and undemocratic foreign interference legal and easy to do. First, secret lobbying is legal. Secret political fundraising of unlimited amounts of money and secret campaigning is legal, including by lobbyists. Secret investments by cabinet ministers, MPs, and senators and their staff are legal. It is legal for MPs to have a secret job on the side. It is legal to bribe someone who has just been elected or just announced as a senator. Anyone and any entity can pay an unlimited amount of various expenses of an election candidate. Lobbyists can give secret gifts to election candidates and secretly sponsored interns in MP offices. Businesses, organizations, and individuals, including those that are foreign-owned or funded, can provide a loan of products and services worth an unlimited amount of money to parties, etc., for up to 3 years, which makes a mockery of Canada's limits on donations and loans. In addition, there are other significant loopholes and flaws that have been mentioned only very briefly during the inquiry's hearings. First, third parties can secretly spend an unlimited amount of money supporting or opposing a nomination or party leadership contestant, or trying to influence a policymaking process. Secondly, one individual or a corporation or organization with just a few shareholders or members can spend more than $1.6 million, as much as a citizen group that has tens of thousands of members, trying to influence an election, and an unlimited amount of money trying to influence a policymaking process, with no disclosure of the sources of the funding. Foreign governments, parties, businesses, etc., are allowed to try to influence voters in federal elections. Canada's donation limits allow donors to give 45 times more than the $75 that the large majority of voters donate annually. And this makes it easy to secretly funnel large amounts of foreign money through just a few proxies, as do the third-party limits that allow one person to spend a very large amount. Again, makes it very easy to secretly funnel large amounts of foreign money through just a few proxies to influence elections or policy-making processes. It's legal for third parties to set up an online pseudo-media outlet and post as much disinformation as they want. Nomination contestants, candidates, and parties are not required to disclose their donors until after voting day, and riding associations only disclose their donors once a year. Contestants, candidates, riding associations, and parties choose their own auditors, which makes it easy to choose a friendly auditor who will cover up questionable donations and expenses. As detailed in the analysis of Bill C-70 that Democracy Watch has also submitted to the inquiry, the enactment of Bill C-70 has only closed some of these loopholes, and Bill C-65, which is before the House, will also only partially close some of these loopholes. However, it would be very naive to believe that all or even many foreign agents will comply with the provisions of Bill C-70 that require registering and disclosing their activities. More likely is, in response to Bill C-70, foreign governments, entities, and individuals will use networks of other entities and individuals as intermediaries who will have arrangements with networks of individual Canadians and permanent residents and the organizations they are involved in to act as foreign agents here. These networks will obscure and make it very difficult to establish that any Canadian individuals or organizations are under the direction of or have an arrangement with a foreign government, entity, or individual. Therefore, as in so many areas of public policy, and as many inquiry witnesses have said, It is clear that an ounce of prevention in the area of foreign interference is worth a pound of cure. Foreign interference activities will only be effectively prevented if the loopholes are closed and the flaws corrected, and the policy papers submitted by Democracy Watch set out recommendations for making these key changes. The papers also recommend using the Supreme Court's egalitarian model as a key basis for Your Honor's final recommendations. Even if all the loopholes are closed and flaws corrected, no law enforces itself. The inquiry has heard little about the systemic flaws in the enforcement entities for all the key laws that protect Canada's democracy from foreign interference. All of the entities lack independence from the ruling party cabinet, which chooses them all, except the Commissioner of Canada Elections, through secretive partisan processes. Many of the watchdogs serve at the pleasure of cabinet. As a result, it is justifiable for the public to view anti-foreign interference watchdogs as being too much under the influence and control of the cabinet. All of the watchdogs are underfunded, slow to act, not required to undertake any effective enforcement actions like inspections and audits, allowed to make secret rulings and bury investigations in secret, and are largely unaccountable even if they let violators off by ignoring clear evidence of wrongdoing. As well, money laundering and proceeds of crime enforcement is weak, and whistleblower protection is weak or non-existent. As well, the federal lobbying and ethics watchdogs cannot impose any penalties for violations, and as several inquiry witnesses have pointed out, penalties in all other areas are too weak to discourage violations. Democracy Watch has submitted a policy paper to the inquiry setting out key changes to make every enforcement entity fully independent, well-resourced, transparent, timely, and accountable, and to establish effective penalties. On another unresolved issue, just before I finish, Democracy Watch urges the inquiry to be fully transparent over the next month, and in its final report, concerning the total number of pages and documents that the federal cabinet has refused to disclose to the inquiry, including about the weeks-long delay in approving the CSIS warrant. Factual conclusions set out by Your Honor in the final report should be qualified if the cabinet refuses to disclose all of its records which show what actually happened in the past decade. Finally, when making decisions about which recommendations to include in its final report, Democracy Watch urges Your Honor not to consider whether political parties will implement any recommendation. The role of the inquiry is to recommend measures to effectively prevent, prohibit, and penalize foreign interference. Please do not let the parties off the hook by failing to recommend any measure just because the parties may not like it or may not implement it. Democracy Watch hopes that in your final report, Your Honor will recommend key changes to close all loopholes, correct all flaws, and make enforcement independent and effective. Canadians are counting on you. Thank you again, Madam Commissioner, for the opportunity to make this closing statement and for the opportunity to participate as an intervener in the inquiry, and best wishes in completing your final report.
Thank you.